Can I have parties announced for the record for the state,
Jason Gearhead, Your Honor.
for the defense?
Michael DeLeon from Minnesota.
And are you Ms. Herrera?
Yes, ma'am.
Counsel, in each of the cause numbers, have you received all of the discovery?
Yes, Your Honor.
And did you review it with your client?
I did.
In each cause number, the court will find that the state is in compliance with discovery. Ms. Herrera, in each of the cause numbers, did you review what's entitled true bill of indictment with your attorney?
Yes, ma'am.
And did you understand it? Counsel, in each of the cause number, do you waive the reading of the indictment?
We do waive rate reading.
All right, stating cause number ending in 8-9, are you proceeding on the indictment as presented?
Your Honor, we'll favor this, Peter. Your,
Any objection?
No objection.
And in the cause number ending in 8-8, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving the enhancement paragraph also. No objection.
Ms. Herrera, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney?
Yes, ma'am.
Did you understand it?
Yes,
Did you sign it in all the appropriate places? All right. Did you understand in the cause number ending in 8-9, you're charged with the offense of robbery and also with the offense of robbery in the cause number ending in 8-8? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea.
Yes, ma'am.
Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent.
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do believe she's competent, yes.
All right, and the court will note for the record that the defendant's competency was restored on June 3rd, 2024. Ms. Herrera, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes,
According to the plea bargaining agreement, punishment is to be assessed at 8 years in the prison. There are no applications. The cause numbers will run concurrently, and the state is taking in consideration 2022 CR 11787. Did you understand that to be the plea?
yes, ma'am.
Defense, is that the plea?
That is the plea, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes.
Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No more. Your Honor.
Then in the cause number ending in 8-8, how do you plead? Guilty, not guilty, or no contest? And in the cause number ending in 8-9, how do you plead? Guilty, not guilty, or no contest? State, any evidence to support the defendant's plea?
Yes, Your Honor. In each of the cases, state exhibit number 1 with all its attachments. We reviewed that, Your Honor. We have no objection.
You may be excused.
Thank you.
Ms. Herrera, did you review the document entitled did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments in each cause number, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We just ask that the court go with the plea agreement.
All right, and the cause number ending in 8-9, the court will follow your agreement. Court will sentence you to 8 years in the prison. Give you credit for any time served. This is to run concurrent with 2022 CR 11788. Take in consideration 2022 CR 11787. And the cause number ending in 88. The court will find you guilty, sentence you to 8 years in the prison, give you credit for any time served. This will run concurrent with 2022 CR 11789 and 2022 CR 11787. And based upon her previous incompetency, I'll request that they place you in the mental health unit. Whether they do that or not, it's completely within their power. I have no jurisdiction to force them to do that, but they'll at least see in the judgment that there are mental health issues.
Thank you.
You're welcome. All right, is there anything else with regards to sentencing in either of these cause numbers?
Nothing else, Your Honor.
Ms. Herrera, in each of the cause numbers, did you review the document entitled Trial Court Certification of Defendant's Right to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. All right, we can go off the record. I can definitely tell you, you're not going to be allowed to possess tasers. You understand?
Yes, ma'am.
And I understand that you have mental health issues, but that doesn't excuse or negate what you're doing. You understand? From here on out, if you pick up another felony case, your minimum is going to be 25 years. Do you understand? Do you have someone who, a support system once you're released?
Yes, my daughter and my son.
All right, good luck to you, okay?
Thank you.
You're welcome.
Thank you, Judge.
Mr. DeLeon, you're going to be here tomorrow. You want to recall it tomorrow?
I don't want to recall it tomorrow, Judge. We actually, I do need a little bit more time to have substantive arguments or communication with the state.
All right. Could you hand me a reset form, please? All right, I can set it for August 26th, 27th, or 29th.
In California at that time with a vacation letter, Judge,
Oh.
I could file a motion for continuance if the.
Oh, well, this is not a trial setting,
So,
and you have never asked for a reset before, so you're fine. All right, so you want to do it the week of the 19th? Is that too soon?
once again, I've got a vacation.
Oh,
letter.
when do you leave for California?
I leave for the, I can do the 19th. I leave for on the 20th.
All right, do you want to come back on the 19th?
Yes, I do have other settings for that date, so that'll be fine.
All right,
Yes,
well,
thank you.
we'll bring you back on August 19th. All right, and you can have your client put her email address on that. Once you sign that, you're excused.
Thank you, Judge.
All right, before you leave, Mr. DeLeon, do you have anyone else on the docket?
Nothing else till the morning, Your Honor.
All right, is there anyone else who's here? Hardaway, what is happening with this case? Could I see the file on Jasmine Hardaway? Yes, what's happening?
She should go.
She's right there.
Oh. Where? Oh, okay. Yes, Your Honor, I think we have a potential resolution of all these cases.
Okay.
Mr. Edelman and I had a discussion about it. It's a little bit off the beaten path. I wonder if you wanted to do that in court or do it in the back.
You want it in the back.
Well, the procedure to employ in this particular case.
All right.
You cool with it?
Yes, you all want to come back tomorrow?
I think we can resolve it today if you think this is the way we can proceed.
All right, if you'll just give me a moment.
Sure.
Okay.
We'll be here. Me and Mr. Doesn't he look like the governor of Minnesota?
Oh,
Chunk-
well, why is he here? Shouldn't he be on the campaign
I
trail?
was asking.
Any objections?
Yes, Your Honor, the defense objects because this contains hearsay within hearsay. So even though it may meet the first level of hearsay under the 8036 business records exception. There is not an exception that's been laid for the hearsay within hearsay that's contained throughout these documents. And so we'll object on that basis.
State,
But Your Honor, I can get to establishing the hearsay within hearsay portion of that. If I get a moment to speak to this.
yes.
Sergeant Martinez, have you had a chance to look over the documents that are contained in that binder?
Yes, sir.
Have you had a chance to listen to the audio recording that's accompanied with, that was accompanied with the documents in that binder?
Yes, sir.
And what was that audio recording?
The audio recording, what was it of?
Yes.
It was a conversation between the defendant and the USA claims representative.
And there's a transcript in 109 of that conversation. Have you been able to compare the transcript and the recorded conversation to one another?
Yes, sir.
And were you able to recognize the defendant's voice?
Yes,
And were you able to follow along with the transcript along with the audio recording?
for the most part, yes.
What do you mean for the most part?
I was the audio recording was a bit choppy, but I was able to follow along with the written transcript.
Was that written transcript, is it a true and accurate copy of what was in that audio recording?
Yes, sir.
Defense?
May I take this witness on board?
Sure.
So Sergeant Martinez, I think what you just stated was.
You may
could-
have a seat.
Oh, sure.
Yes.
I think what you stated is that you couldn't hear the recording in some parts, so you followed along in the transcript. Is that right?
No, sir. I followed along simultaneously.
And maybe I misheard. Did you testify that the recording was choppy and that you had trouble hearing the recording?
A bit choppy in some parts. Yes, sir.
Right. And you didn't do the transcript, nor do you know who made the transcript?
No.
And that transcript is not an official court reporter's transcript or certified as an official transcript for court purposes.
I'm not aware of that.
And the as far as what was choppy, I guess when you're saying that it was choppy, you're saying that you had difficulty hearing, but you looked at the transcript, which helped you to be able to hear it.
The audio just cut in and out very briefly at times, but I was still able to follow along with the written transcript.
But without that transcript, you would not have been able to hear where it cut out.
As far as the words,
Yeah, if you didn't have the transcript, you wouldn't have been able to hear it at the parts where it was cutting out.
I don't believe it cut out long enough at any point in time where it cut out whole words.
But there were partial words, I guess, and I'm just trying to understand. So there were partial words that were cut out that you weren't able to hear, but the transcript aided you in being able to hear what those words were.
I feel like for pretty much the entirety, I was able to recognize the words that were on the written transcript and the audio words from the audible transcript or the audible recording.
Understand. Your Honor, I guess at this time, that's not the only hearsay within hearsay issue, but I do believe that including a transcript that is not a certified transcript, that this witness cannot testify where the transcript came from, who did the transcript, and all of those things. There's rules about transcripts, and when they're offered in a court of law, they have not followed those rules, and so therefore we do not believe that that should be admitted. Additionally, that's not the only part where there's hearsay and hearsay. There's a lot of letters back and forth from lawyers. There's legal documents. There's other things that all qualify as hearsay within hearsay. I don't.
With regards to the letters, can I have parties approach, please?
So, Dr. Martinez, have you had an opportunity to look at the documents that are involved in States 109?
If you're referring to that large binder, yes.
109A resides. Well, I'm going to show you part of what's in a 109A. I had an opportunity
to see this email.
Yes.
And who is the email sent by?
It's sent by the defendant
And who's it to? Can you tell?
to USA to claim their claims.
Okay, would you be able to read what the email says?
Your Honor, I'm sorry, I object to hearsay. I'd like to take the witness on board about how she could identify that that email was sent by the defendant.
All right, the objection to hearsay will be overruled.
Speculation as well, as far as the fact that she can't identify. We don't have any evidence.
All right, state, lay the foundation if possible.
Are there any other emails here where the defendant identifies himself?
Yes,
Okay, and what does he identify himself as?
by his name, Alexander Castro.
All right, objection is overruled. You may proceed.
If you could read, beginning from where I'm pointing.
Sorry, the font's little. Hello, anything yet on the photos or even a response? I have tried calling, but have not yet been able to speak with her. Is there anything you can do on your end because this has dragged on long enough? I will keep calling, but maybe you'd be able to as well, or be able to speak to her supervisor. The number is 210-207-7385. Detective Ramirez or the SAPD case number should get you in contact with someone. Like I said, I will keep trying as well. Thank you.
So it mentions there that that it's been dragging on for long enough. What was the date that this email was sent?
This date shows September 13th of 2022.
And how long after the crash here was this sent?
That would have been less than 2 months.
And there's a phone number that was given out in the email. What was that phone number?
That's the phone number to the traffic investigation detail.
And have you had an opportunity to look at the other emails that are contained in this binder?
Yes.
And in states 109A, are there other conversations about reaching out to you regarding photos for processing the claim?
Your Honor,
Yes.
object to hearsay if it's not the statements of the defendant.
All right, if it's not the statements of the defendant, that will be sustained.
And are these emails sent?
Your Honor, I'm sorry, may we have an instruction for the jury to disregard?
All right, ladies and gentlemen, you'll disregard the last question. You may proceed.
If it's moves for mystery.
Denied.
Does the defendant in other emails talk about the claim being processed?
Yes.
And does it create context for what he's talking about here about the claim dragging on for too long?
Yes.
Your Honor, I've just object to hearsay again. It's a backdoor way of hearsay where he is speaking about things that the court has sustained.
All right, overruled. You can answer the question.
Yes.
And I'm going to show you one other section in states 109A. What am I showing you here?
This is the transcript of the audio conversation that I reviewed.
And have you had a chance to read the transcript recently?
Yes.
And what detail, well, one, who's a part of the transcript?
So it's the claims representative from USA, and it's the defendant, Alexander Castro.
And does it indicate when did this conversation take place?
Uh,
In here.
So here it's the USA representative speaking, stating who she's speaking to, and she states the current date for the conversation is July 29th, the time at 2:11 p.m.
What year? July 29th of what year?
No, sorry, July 29th, 2022.
So how long after the crash was this?
That would have been 7 days later.
Okay, and in this transcript, is the defendant asked about what happened in the crash?
Yes.
And what does he indicate?
Basically, he gives similar details that he's not sure about a lot of the details. I don't know specifically what you're referring to.
Well, does he give an indication as to where he was going?
He said he was going home.
And you've had a chance to review Officer Morgan's body cam.
Yes.
And is what he said here in that transcript, is that different from what he said on the body cam?
Yes.
Well, what did he say on the body cam?
He told Officer Morgan that he was going to get a friend.
And are you aware, where does the defendant live? What city?
At the time of the crash, he resided in Shirts.
And in order to get home, would he have had to have taken 281 to get home?
No.
So speaking of defendant's location.
Can you wait until you get in front of the mic?
Yes, ma'am. I'm going to show you what's going to be marked as state exhibit number 110. Do you recognize what this is?
This is the search warrant I filed for the defendant's vehicle.
Well, what specifically were you looking for in the defendant's vehicle?
I was requesting to retrieve, so the defendant's vehicle has two different modules. Aside from the airbag control module, there was a Bosch multimedia module and an LG OnStar module. So I was requesting to retrieve those two modules.
Well, can you explain, why would you want to get those two modules?
So the information that they store, those modules specifically are for the infotainment center. And most vehicles are in the center console area. So the large screen that everybody kind of navigates through for media, navigation, just things like that for the vehicle. So all that information stored in those modules.
And have you been trained to extract that information from vehicles?
Yes, I've been certified both as a technician and an analyst.
And is this states 110, is that a true and accurate copy of the search warrant that you submitted?
When the jury comes in, you will offer it as 109, and 109 will include the defendant's, whatever statements the defendant's made, but the part that I sustained, the hearsay objection, that will not be in the 109 that goes with the juror. So, all right. So what you'll be offering will be State's Exhibit 109. Okay. And then we'll start with this hearing. All right, so we're outside the presence of the jury. So people ask your questions, all right? And then the court will make a ruling.
I'm sorry, Judge, I thought they might have some questions first.
Mr. Goff, can you get the microphone, please?
Yes, ma'am. And just so I'm clear, I mean, I'm just making an assumption that they're offering this.
They've already offered it.
I thought they
You
just offered the
they
search.
offered the search warrant and you requested a hearing outside the presence of the jury. You requested the hearing, so please ask whatever questions you wish to ask of the witness, and then the court will make its ruling.
Yes, Your Honor. I think really the main question is, we have the exhibit.
I think Judge has.
Okay.
It's
Yeah, of course.
110.
110. May I approach the witness?
Yes.
Sergeant Martinez. I'll show you what's State's Exhibit 110. And in State's Exhibit 110, do you see that you have I guess, a probable cause affidavit that you've included as part of the warrant?
Yes,
And you were here for the motion to suppress that was done last week of the defendant's statements.
yes,
And you remember when the judge suppressed the statements that he made to you because he had been in detention?
yes,
And those statements are included in 110 as part of the PC that you used to get the evidence that you got with the GPS. Is that right?
they're a small portion, but yes, they are in here.
So the statements that he made to you that have been suppressed by this court are included in this affidavit that's found in 110. You would agree with that?
Yes,
So for that portion, Your Honor, we would say that the statements made, since they have been suppressed.
Right. Well, first, do you have any more questions of the witness?
I will if the court is allowing.
Well, we're doing a hearing, so if you have any more questions with regards to your objection to State's Exhibit 110, please ask them.
You would also agree that this statement, may I approach the witness?
Yes.
Thank you. Exhibit 110, you would agree that this was a statement that was made by you outside of court, right?
yes,
Okay, and so you weren't in this courtroom when you wrote all these things down.
no,
And in this, you make assertions about what happened with the crash. You made assertions about your observations that you made at the time. And you made assertions about the things that were told to you and the things that were said at the time. You would agree with that?
yes, based on evidence and statements, yes,
Based on the evidence and statements. And all those assertions that you made were assertions that were made outside of this court.
yes.
Your Honor, may I consult with plea counsel
Mhm.
briefly? Your Honor, may I approach again?
Yes.
Thank you. Do you remember when you were at the scene, I guess, I want to talk about the purpose of why you got this warrant. That speed alone, you would agree that you have an understanding, and I think we even have it on the body cam. That speed alone is not sufficient to get a warrant. Judges wouldn't sign, or your belief is the judge wouldn't sign a warrant on speed alone. They would need other details like the details that you provided in this affidavit to get a warrant for the GPS and the other things that you're asking for.
Correct. That's why I was doing my investigation.
Understood. As to Exhibit 110, Your Honor, I'd have no further questions as to Exhibit 110.
State, any questions?
No, Your Honor.
All right, then the court will hear argument.
Yes, Your Honor. So as the court knows, an officer search warrant is hearsay, and they are almost never admitted in front of a jury, and they're never admitted as an exhibit because the search warrant statements and assertions that are made are used for the truth of the matter asserted. And because they are out-of-court statements used for the truth of the matter asserted, it's hearsay and should be excluded on that basis. Additionally, whether or not there was probable cause to get the evidence is a law determination that is made by the court. It is not a fact determination that should be made by the jury. And so therefore, especially because we're in a punishment phase, there's not even a 3823 issue. So because of that, the more proper venue would be for the court to review the search warrant and review the evidence they're trying to get from that and make a legal ruling, as is the court's power and right and responsibility, and not have it go in front of the jury, which is not their, it is irrelevant for the jury to know or understand about the specific statements and hearsay statements that are made in the warrant. Additionally, in this warrant itself, because the court has suppressed statements that are used to form the basis for probable cause, in this warrant, the fruit of the poisonous tree would dictate that that this warrant should not go in front, especially with those statements. And really, our argument will be, right now we're arguing just with the admission of the warrant, but then our argument will then move on to what the warrant obtained and why the warrant was faulty in that instance. And so that's why we're asking the court to sustain the objection to hearsay on Exhibit 110.
With regards to the search warrant, so that the record could be clear, the statements made by the defendant that the court granted the defense motions to suppress, and that would be the statement specifically to this officer only. And that statement that's in State's Exhibit 110 is the following. The suspect admitted to consuming alcohol prior to the crash, but claimed he only drank 4 beers and claimed he stopped drinking approximately 6 hours prior to the crash. The court is not considering that statement or any statements that were made by the defendant to this officer in making a determination on whether or not there was probable cause with regards to this search warrant. The court is, however, not suppressing any observations that this officer made. For example, in State's Exhibit 110, it states that this officer smelled an odor of intoxicants emitting from the suspect's breath. So defense, if you will refer, defense, do you have a copy of this?
Yes, sir.
All right. State, do you have a copy of this? Is your only copy that I have?
Judge, I just exited out of Adobe Eye.
All right,
Sorry about that, Judge.
no problem.
Yes, Judge, I am.
All right. So if you all will turn to page 2, defense, are you on page 2?
Yes, sir.
All right, the last paragraph on page 2, where it's states the suspect admitted. So the court is not considering that whatsoever. That is the only statement that the court sees where the defendant made a statement to this officer. Is there any other place, defense, that you see where it's alleged that your client made a statement to this officer?
Yes, Your Honor. If you look above that, it's still at the beginning of that paragraph.
Mhm.
I spoke with the suspect approximately 4 hours, and he was unclear about how the crash occurred.
All right, and the court is not going to consider that as well.
Understood.
All right, so the court will not consider that. Is there any other place that you all see in States Exhibit 110 where your client is alleged to have made a statement?
Well, I guess it's just in her conclusory paragraph that she does on page 3. She includes his statements as part of that conclusory paragraph.
All right, what paragraph number is that on the last page, counsel?
Paragraph 2 on the page that has the signatures on it.
Okay.
And admitted to drinking prior to the crash.
All right, and the court will not consider the part where it states that he admitted to drinking prior to the crash?
Judge.
Yes.
Just on that point, there has come already testimony from one of the other officers that the defendant did admit to drinking alcohol.
No, I'm just dealing with specifically what's in this search warrant through this officer. So any statements that is alleged to have been made by Mr. Castro to this officer, the court has already suppressed that. So with regard to that page, counsel, that part of the sentence where it states that your client admitted to drinking prior to the crash, the court is not considering that and making a determination of whether or not probable cause existed. Is there anything else from either side?
Only a clarification,
Yes,
if I may, that,
of course. And you can remain seated.
okay, thank you, Judge.
I find that people hear better when everybody's seated.
Sure, just so that I'm clear on, as you know, to preserve the error, I have to make sure I'm making the right objections at the right time. So I believe what the court is doing is a probable cause analysis of the statements and the information left in the warrant or the PC affidavit.
Yes.
But we are not discussing whether or not this goes in front of the jury. We're just
No.
discussing this for the, okay, thank you, Judge.
Sure.
I have nothing further after that.
All right. So that the record is clear. In reviewing the affidavit for the search warrant on whether or not probable cause existed, the court is not considering statements made by Mr. Castro to this witness. The state previously granted the defense's motions to suppress statements that Mr. Castro made to this specific witness. So in reviewing the search warrant, State's Exhibit number 110, and determining whether or not probable cause existed, the court is going to find that probable cause did exist with regards to the affidavit for search warrant, and that is excluding Mr. Castro's statements. Now that that is done, the next question is whether or not State's Exhibit 110 should be admitted before the jury. Defense, what is your objection?
Yes, Your Honor, our objection is hearsay.
State.
Judge, again, this is not for the truth of the matter asserted. It's, again, it's to show that the search warrant was obtained lawfully and that it's not to conflate this with the earlier search of the truck.
Your Honor, if I may respond to that briefly.
Well, just a moment. Isn't she able to testify that she obtained a search warrant?
Yes, Judge.
So then State's Exhibit number 110, is it needed to be admitted?
No, no.
All right. Thank you. Let's bring the jurors back in.
Your Honor, may I just, as far as, just for your timing, I believe that the next thing that they're going to do is try to offer the things that came in from that, and we would be requesting a 705 as to her expertise on those matters. If that, I don't want you to have to make them go in and out if you didn't want to, but we'll do whatever the court would like.
Well, we'll see what is being asked for. I have no idea
Yes, Your Honor.
what's going to be asked for from this witness.
Yes, Your Honor.
All
Understood.
right. All right, let's bring them in.
All right, for the jury.
Microphone.
Oh, excuse me.
So Sergeant Martinez, were you able to obtain a search warrant in this case?
Yes.
And what were you in particular looking for?
I wanted to extract the Bosch multimedia module and also the LG OnStar module from the Chevrolet Silverado.
And you may have answered this before, but are you trained in how to pull that data from vehicles?
Yes, I'm a certified technician and analyst for those types of modules.
And what type of training did you receive to be able to pull the data from these models?
I'll refer to my resume. So I received my Burla Vehicle System Forensics Technician and Examiner certification. That was back in March of 2022.
Can you explain to the jury, what's Burla?
So Burla is the company that basically provided the training. They also provide the software and the hardware in order to download those hard drives.
And what exactly would the program show if one were to download this data from a vehicle?
It's make and model dependent. For the most part, it shows navigational data such as track logs. There'll be, timestamps. Typically with the multimedia modules, there's information as far as connected devices to the vehicle. Some makes and models will even give us transcripts of text messages that are sent and received, audio recordings. There's a lot of various information that we can get.
And is this training in the program that you were trained on, is this something that's widely used in just any type of police or investigatory field?
To my knowledge, it was becoming more and more popular at that time. So now I would imagine it's widely used. Yes.
I'm going to approach with what's been marked as State's Exhibit number 111. You recognize this?
Yes. So this is one of the track logs that I was able to retrieve from the LG OnStar module.
And what vehicle were you able to retrieve this from?
This is from the Chevrolet Silverado.
And were you able to get any more information from the truck that verified or at least matched up with the information you see here?
Yes. So these these timestamps coincided with map. So
Your Honor,
whenever
I
you
just
open,
object to her testifying from a document, not an evidence.
All right.
Hearsay.
Sustained to hearsay.
Well, is this a true and accurate copy of the information that you obtained from the defendant's truck?
yes.
Your Honor, state what offer states exhibit number 111.
Your Honor, we would object to speculation as to this witness's ability to extract it and request a 705 hearing as to her expertise.
All right, ladies and gentlemen, I'm going to have you wait in the back of the jury room. And I will probably bring you back no later than 3:15. All right, everyone, please rise for the jurors.
Your Honor, may I start by, well, here, I'll ask this question first. Sergeant Martinez, I noticed that you've been looking at, I guess, some documents that you have as far as reminding yourself, I believe, of your trainings and your Burla training or whatever else is that. Do you have documents up there like that?
It's my resume.
Yes, and Your Honor, under the rules, I just asked that I be allowed to look at a copy of that.
Sure. Could you let defense counsel see your CV, please? Is there an extra microphone?
Oh, that,
Excuse me. Here you are. So you all won't have to be switching back and forth here.
thank you.
You're welcome.
Sergeant Martinez, in particular, I think you referenced this as the LG OnStar module.
Yes.
And as far as the LG OnStar module, did you have any information that that the GPS track logs that were recovered, was that track logs that the defendant was inputting into the system, or was this being tracked without, I guess, without his input, if you know?
So that's not something that the module specified. It basically just gave me the time-stamped track logs.
So you were unaware if this module was tracking the defendant without his knowledge that he was being tracked?
It's a system that basically just pinpoints GPS points as you're driving.
Sure. And I guess the question I have is, you were unaware, though, that you don't know if this was tracking him without his consent or without his knowledge that he was being tracked. You don't know if that was the case or not.
I'm not sure if he was inputting the navigation or if it just recording navigation.
And are you aware if this system has any ability for somebody to opt out of being tracked at all time without their knowledge?
Usually OnStar is a service that you have to subscribe to. But as far as the module storing data, I'm not sure if it requires a subscription in order to record the data.
Okay, but did you check or did you ask did you ask to see if he did subscribe to OnStar, the defendant?
No, I didn't check with OnStar.
Okay, so as far as you know, the OnStar could have been tracking him without his knowledge. When he was going to these different locations that you pulled out of the module.
I imagine that's possible, yes.
And you understand that, for instance, if I put a tracker on somebody's vehicle without their knowledge, that could be a crime.
If a person does it, yes, yeah.
If a person or a company puts a tracker on somebody's vehicle without their knowledge, it could be a crime if they're not giving the person notice that they're tracking. Is that, you agree with that?
Okay.
Because you know that people have been arrested for putting unauthorized trackers on other people's vehicles,
Yes, like stalkers.
like stalkers, right? And so, as far as in this particular, just so it's clear for the record in the court, because the court hasn't seen this, Exhibit 111 that you were referring to basically is a page that gives you addresses that you're saying that the defendant's vehicle went to that evening before the crash.
I believe that one just has a date and timestamps and distances covered. I don't believe it details any addresses.
Okay. And did you, or was it your intent to provide testimony to the court and to this jury that you could tell which addresses that the defendant went to?
Not specific addresses. It gives locations. Typically, I can pinpoint it down to like roadways traveled, intersections, things like that.
Right. And would that be on a different document than State's Exhibit 111? I'm sorry, you need to see it.
It's not on that document.
Yes, you can approach.
Okay. I think we got the answer. So the information you're talking about, is it your intent? Because I don't know. Is it your intent to testify about specific locations that you believe that the defendant went to?
If that's the questions that they're going to ask me, yes, I can.
Okay. So as far as Exhibit 111, is it your intent to testify that you extracted data from the vehicle that you were trained to extract from the Onstar, let me get it right, the LG Onstar module? And your intent is to say that that you believe that the vehicle drove this many miles?
Based on the track logs, yes.
Right. You do not know who is driving the vehicle though, based upon the information.
At those specified, not at all of those specified times, but the times go up until the time of the crash.
Which you do know he was driving at the time,
Correct.
but not before.
Not prior to, no, sir.
And do you remember discussing with Agent Peterson that your OnStar data that you recovered had time gaps of missing data?
I believe, yes, there was some time that was unaccounted for.
And because I know you've been trained to extract, but you have not been trained in the actual workings of how the OnStar module works as far as being able to diagnose why there was missing data or if it was working properly.
It appeared to be working properly. There weren't any errors that I received. Missing data, there's a lot of explanations for that, especially when it comes to GPS data.
Okay, sure. But I guess the idea is that you cannot say what the purpose or what the reason is for the missing data in this case on this car that you extracted the data from.
I can say that it did not appear to be a malfunction.
But you cannot say why there was missing data.
Correct.
And if we thought about like how long, it was you would say almost a 2-hour time gap of missing data.
From the track logs, yes.
From about 8:10 on the evening before the crash, on the date before the crash, to 9:57.
I'd have to see the track log.
Yes. What mark? What number? Your Honor, may I first witness with the exhibit?
Yes.
I don't know the number and we don't have a sticker, but I would ask to mark it next in order if the court does know what the next one is.
All right, is it a defense exhibit?
It's a defense exhibit. Yes. Sir.
All right, for purposes of this hearing, you want to mark it as 3 with a letter? All right, defense? Ms. O'Gean,
Yes.
3A?
3A. Okay, Judge.
Currently,
Yes.
approaching you with what I've marked as Exhibit 3A for the purposes of this hearing. Does this look like the email that you and Agent Peterson sent back and forth to each other?
It appears to be yes.
And I guess if you can look at the top part of that, does that help refresh your memory as to the times of the gap that you observed?
Yes, I notated the time gap from the track log. And later we were able to fill in the majority of that time.
Okay, and was that time, as I said, 8:10 to 9:57?
Yes.
Your Honor, as to 111, this is all that I have. I do understand that they plan on offering the location data. And so I guess having the jury go in and out, and it looks like I'm the one that's making them keep getting up and going in and out, I would prefer, if the court is amenable to it, for us to just get all of this out right now while the jury's out, so we can have this hearing and the court can make a ruling on all.
Do you have any more questions about location data?
I do not have any more questions about 111, but they're going to offer 112, I believe, that's going to show specific locations.
All right, with regards to 111, the court will hear argument.
Yes, Your Honor. So I guess first and foremost, our objection that we are going to make is under 3823 of the Texas Code of Criminal Procedure. The state cannot show that this data was not collected in violation of a law of the state of Texas, as 3823 states, that it can be a police officer or any other person. Person has been defined as corporation in the code. So a corporation can be considered a person for those, like a corporate person. And what we would say is that OnStar has collected data unbeknownst to a person, to the defendant, which is in violation of 3823. I understand under the Fourth Amendment that law has been interpreted that it is only state actors. However, in the state of Texas, if there is a violation of state law by any means or any person, then that can and should be excluded. So we're asking
So
for.
are you arguing that OnStar's collection of data is illegal?
I'm arguing that OnStar's collection of data without there being any proof that the person was notified that they were collecting data. Because in this case, if he had signed up for OnStar, I can understand that. But what the witness testified to is that they are collecting data even when somebody hasn't signed up. Or they could be collecting data even when a person has not signed up for the service. If you sign up for the service, you have to check off the terms of service. But if you have not signed up for that service, then they are collecting data without the person's consent or knowledge. And that is a crime in the state of Texas.
So you're arguing that OnStar is giving free services to everyone?
My understanding is that this is not, the defendant was not using OnStar, and OnStar was surreptitiously tracking the defendant without his knowledge. He was not using their service. They have not provided any evidence that he was using their service, and I believe that he was not. The issue with that is that I think many people would be surprised to know that OnStar is tracking you even if you haven't signed up for their service. And that is what the witness testified to, that these modules will be tracking the person even if they have not signed up, which would be a violation under 3823, and this evidence should be excluded because of that.
All right, state.
Your Honor, there's been no evidence that OnStar collected this information through a violation of the law of the state of Texas. At this point, it's speculation that the law was violated. There's been no evidence that the defendant didn't know or that had no knowledge or anything of that sort. So we'd ask that the evidence be let in.
All right,
I do have-
defense, I'll give you your final argument.
I have further argument just as to the veracity of this particular data, moving past the 3823 argument. The witness did testify that there is an unexplained gap in the GPS and in the location services. That unexplained gap cannot accurately be explained by this witness. And so we would argue that this witness does not have the sufficient technical knowledge to be able to explain to the jury what it is. And finally, evidence of where he has gone at the, on the evening, and I guess at the time in question, is not relevant, and under 403, it should be excluded as well.
All right. The objection by defense is overruled. The court is performing a 404-3 balancing test. The court is going to find that it's more probative than prejudicial. Let's move on to the next issue. Is there something else that counsel that you find objectionable that the witness will be testifying to?
In conversations with the state, they have told me that they intend to offer the actual locations where the defendant was. And I would like to be able to 705 this officer on that particular issue.
All right, you may proceed.
Sergeant, I think that one of the things you testified to is that in addition to getting, I guess, the times of driving, even though you don't know if it were him driving, that you pinpointed some possible or potential locations. Am I right about that?
Yes, sir.
Okay, and the locations meaning like locations where he was or where you believe that the car was.
Where the vehicle was driving and parked.
Your Honor, I'm sorry, may I approach and retrieve defendants 3A?
Yes.
Oh, I'm sorry, I gave it to them. In that situation, what you were able to testify to is that you cannot say exactly where a person is. You can just say they are in the general area or the general location of a place. You would agree with that?
Based on the data that I had, yes.
Right, because a person, if there are two shops next to each other and one shop is a dress shop and one shop is a suit shop, you wouldn't know which one that they were actually located at.
I was able to determine where the defendant was at a later time with other evidence.
With other evidence, but not with the evidence here.
Not solely with my evidence. I placed him in a general vicinity or at a location. Yeah, if there were multiple shops or bars or restaurants at that location, then I wasn't able to pinpoint the exact location solely with my information.
Sure. And so what you did is you had to rely on out-of-court statements from somebody else, namely Agent Peterson, who went to those locations. Is that correct?
Correct. TABC agent Peterson worked in assisting as far as getting further evidence.
And so TABC agent Peterson is the one that told you that I believe he was located here based on other evidence that's not included in what you were able to gather from the GPS data.
Correct. He provided sales receipts.
So you had sales receipts that were provided. Notably, though, there were no sales receipts in specific to the Hills and Dales establishment that you believe that the defendant was located at hours before the crash.
Nothing, to my recollection, nothing was obtained from Hills and Dales.
Okay, so what you're testifying to really is that for that location and others based solely on the GPS data, you could not testify to where the defendant's car was located without having that other information or without having those out-of-court statements from Agent Peterson that he made to you at the time of your investigation.
I could testify to where the vehicle was at the times from the track logs.
I guess when we say was, I'd like to be specific. You can testify to a general location, but you cannot testify to where it actually was solely based on these logs.
No, I can say where the vehicle was. If you're asking if I can say where your client was, then no.
Well, I guess what I mean is that even in where the vehicle was, there are different locations that the vehicle could have actually been located at. It doesn't go within like an inch. It goes within an area, a generalized location area that is, I guess, that is more than just the exact location.
They're within feet. The GPS track logs are within feet. So whenever the GPS is tracking it on the roadway, like on a specific roadway, I can say with absolute certainty that the vehicle's on that roadway.
If the vehicle is on that roadway,
Mhm.
but not exactly where it is on that road.
Within feet.
Well, you're saying within feet. So sometimes you can tell within feet, but as you know from your training, with GPS locations, just like you don't know sometimes why there's a gap in the data, sometimes GPS location can be off by more than feet.
It's tracked within seconds, so it's doing a constant track log. That's the point of the track log. So it's not pinpointing a specific spot just at this time. It's doing it in a log. So every few seconds it's tracking, and that's why it shows up as a log, as a route per se.
Sure. But I guess what I'm saying is that if a car or a vehicle that is being tracked is stationary, then it is stationary, but there are sometimes you can tell within a few feet, and there's sometimes that the distance is actually further based upon GPS technology.
Yeah, not a substantial amount of difference in distance.
So you would say that if you testified, you could only say that a car was at a location. You could not say that the defendant was at any location based upon this.
Based solely on that information, no.
Your Honor, pass the witness.
State,
Nothing from the state, Judge.
all right, court will hear argument.
Yes, Your Honor. We would renew our 3823 argument. I understand the court has overruled it, but we do have to keep asserting it. And so I guess may I assume that the court is also overruling me on the 3823 issue?
Well, I'll hear your argument.
Yes, Your Honor. So the same 3823 issue that he is being tracked, they have not shown, and nor did the witness even try to get any information that he had actually signed up for this service or that any of this was consensual or with the defendant's knowledge. But moving to the specifics of the location, this witness would have to rely on statements that are made to her, hearsay statements that were made by an out-of-court witness, used to prove the truth of the matter asserted, to wit, that the defendant was actually located in a specific place.
All right, and this out-of-court witness that you're speaking of, would that be an officer and a part of the investigation?
It would be a TABC officer, and it would not be a part of the investigation. The case law is pretty clear that the idea that information acted on, which is commonly used, can be used to explain why an officer went to a particular location or went to a particular place, but it cannot be used to show the truth of the matter asserted. And in this case, a very testimonial statement, which is from Agent Peterson, which is the defendant was located in this bar at this time. And so that's ultimately what we believe the state is trying to do, is say the defendant went from bar to bar to bar. But this witness cannot testify to that because she would have to use an out-of-court statement that is a testimonial statement that goes way past the information acted on exception or exemption to the hearsay rule. And so as far as this witness being able to do that, she does not have the sufficient information to be able to say that the defendant was in any of these places. And then because of that, showing that a vehicle was located becomes the probative value of that, without being able to say that the defendant was actually there. The probative value of that becomes way less, and the prejudicial danger of that becomes way more. And so now we have under 403 additionally, that if she is allowed, based upon hearsay, to say that the defendant was drinking at a bar, which is what we ultimately think that that's the purpose of this testimony, then she is being able to get that from hearsay and other things that do not qualify under hearsay exception.
Okay, thank you. So the court is doing a 403 balancing test. The court is going to find that it's more probative than prejudicial. State, with regards to this witness, based upon what I've heard in this hearing, this witness cannot definitively say that the defendant was at a specific location or inside a location. So the defendant will not be allowed to testify that the defendant was at a specific location. However, if this witness is planning to testify, and I have no idea what she's planning to testify to, if she's planning to testify, for example, that the defendant was at location A, and at location A, just hypothetically, is Target, Walmart, HEB. Then this witness can testify. Defendant was at the vehicle, was at location A, and there's Target, there's Walmart, there's HEB in that vicinity. And then defense, you'll have to cross-examine. Is there anything else? All right, and
For
if
the
I could
defense,
have
I'm sorry.
parties,
I'm sorry briefly, and I understand.
and if you'll give two to the state as well. And there's something else you wanted to add to the record, counsel?
Yes, Your Honor, just so I can make clear, going back to the 3823, may I assume the court's overruled that
Yes.
objection? Thank you. And then may I have a running objection to all of these objections that I've made as to her testimony so that I don't keep having to stand up and object while she is testifying, only to the specific things that we've discussed here in the hearing.
You can make whatever objections you wish to make, counsel.
I understand. So, and I know it's within the court's discretion to give me a running objection. Is the court denying the running objection?
You can make whatever objection you wish to make, counsel.
Yes, Your Honor.
All right, so any other questions? All right, so off the record, I've just given you all the copy of what you requested from the charge. So those are the 2 pages. Those will be the last 2 pages. So it's page 5 and 6. So if you'll just remove the current pages and defense, that's adding the bias or prejudice that you wanted added. And then I'm going to take this plea up, counsels. We'll take the plea up, and then after I take this plea up, we will bring the jury in. All right, court is calling 2022 CR 7550B, State of Texas versus Jasmine Hardaway. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
Ed Shaughnessy.
All right, and are you Ms. Hardaway? All right, counsel, have you received all of the discovery in this case and did you review it with your client? Court will find that the state is in compliance with discovery. Ms. Hardaway, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it? You need to speak up.
Yeah.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, you're not, Your Honor. We're waiving count 2, proceeding on count 1 alone with the lesser included offense of assault bodily injury, Class A misdemeanor.
Any objection?
None.
Did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand that the state is proceeding on the lesser included offense in count 1 of assault bodily injury as a Class A misdemeanor? Range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you are giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
And so taking a look at state exhibits number 112 through 120, what exactly were you looking at?
So these were the maps that correspond with the track log points in the Burla system, the software system.
And what exactly do these points show?
So they're GPS tracked points, and they show basically a route that the vehicle took from a starting to a stopping point.
And the points that are in the maps, do they correspond to the track log that that's contained in state's exhibit number 111?
Yes.
And are these true and accurate depictions of the track logs that you saw?
Yes.
Have they been altered in any way?
No.
Your Honor, state would offer state exhibit numbers 112 through 120 and tender to defense.
And Your Honor, we just would stand on our previous objections.
All right, and can I see State's Exhibits 112 through 120, please? All right, defense, your objection is no, it will be overruled. State's Exhibits 112 through 120 is admitted.
Permission to publish, Judge.
Granted.
I'm showing you what's been marked in state exhibit number 112. What are we looking at here?
So this is a map of one of the track logs. And to my recollection, the starting point would be this initial blue dot that's on the far right of the paper on 1604. And the vehicle is tracked down 1604 to 281 through a turnaround and then through local roadways to an endpoint. I believe it was like 15,800. I wrote it in my report. 13,800 Jones Maltzberger Road.
And Sergeant Martinez, if you'd like to step down from the well, so you can kind of point towards the exhibit. So that the
Okay.
jury can see. Well, just for the record, the state's gonna re-offer state's exhibit number 1. Re-offer that.
All right, and any objections to the redacted 109?
If I remember correctly, that is, I did make objections to the fact that the transcript was not a certified transcript. If that is part of the new 109, and so I would renew that objection, but no further.
All right, objection is overruled. The redacted 109 is admitted.
I'm gonna show you state's 109. Just to clear up a few things.
I'm gonna ask, and I'm gonna point towards the paper because that may be the easiest way. Well, what was the question here? Can you read from this point?
Question shows, what was the purpose of your travel? Where were you going?
And what was the answer?
Answer shows, I was actually just with a friend, and then I was on my way home.
Okay, and again, you're familiar with where the defendant lives?
Yes, sir. At the time of the crash, he resided in Shirts.
And so looking at that vehicle track log, it appears that the vehicle turned on 281 where the crash occurred. Is that correct?
Turned on to 281.
Yes, leaving the area where Hills and Dales is.
The track log shows the vehicle traveling eastbound on 1604 and then northbound on 281.
And so if that vehicle was going to travel to the defendant's home, what road or highway would it have had to have taken? Are you aware?
He should have continued on 1604 eastbound all the way to 35 north.
But instead, again, it turned north on 281.
Correct.
And then I'm going to point to here. Can you read that question and answer?
Question shows traffic heavy, stop and go, or maybe light.
What was the answer?
Answer, it was actually kind of light.
Okay, and then from here, can you continue reading?
Question shows, where did this take place? What's the name of the road, or where did it happen? Or where did that happen? Excuse me.
And what about the answer? And you can continue reading up until, I'd say about this point. Well, right up until there, where my finger is. And you can continue reading.
Stop here.
Yeah.
Shows answer, it was on Highway 281, northbound. Question, and what's a nearby crossroad or nearby intersection? Answer, Evans Road. Question, okay, this part of 281, does it have 3 lanes each way or is it more or less? Answer, it's new construction, but it is, yeah, I believe it's 3 lanes. Question, and what's that speed limit there? Is it 55 or 65? Answer, I believe it's 65. Sick.
Okay. Okay. I'm going to start here. Can you start with reading that question?
Question, so if you could walk me through, tell me what happened. Answer, so I really don't remember a lot of the accident. It was a very bad accident. I know that my truck had flipped over and I know that there were multiple vehicles involved. But as far as like putting things together, I really can't. Like all I see in my head is just like, and it's almost like a movie, like pauses, but everything just kind of exploded and was flying around in my truck.
And then continuing on to the next page.
Question, wow. Answer, yeah, it was like really still shaken up about it. Like this was Pauses inaudible. I mean, you only see accidents like this in movies. Like,
Then again, continue reading, please.
question. Answer. Car crashings and stuff like that. Question, yeah. Answer. It's really wild. I don't remember if the other car actually got into the side of me, and that's what flipped me over. But looking at my truck, there's damage from both sides and the front end. So I mean, size and the way my arms and my ribs feel, like I feel like they were just flying around everywhere. Like I was thrown around like a rag doll. Just kind of like pauses, another voice audible, being held in by my seatbelt. I mean, I'm very lucky to be alive and like walk away from this. But it just like pauses mentally. I can't process or put anything together. You had just left with your friend? Answer, yeah.
And continue.
Question, okay. Answer, no, I just went to see him for a little while. I didn't, yeah.
Here, can you continue reading?
Yes. Question. So I hate to continue to ask these types of questions. This is going to get a little sensitive. But as far as the number of vehicles that were involved, do you think, do you think it was more than 3? Answer. There was 4 vehicles involved. One of them was a 18-wheeler.
And if you can continue. Right up until this point.
Oh, stop here.
Yes, ma'am.
This is shows answer. And I think that's the one thing that I remember hitting because I guess I was sliding. And then when the truck flipped back over, I believe that the 18-wheeler is what stopped me. Question. Okay. And then what time of day was this? Answer. It was early in the morning. I want to say it was around 1:30 or 2 o'clock in the morning.
I guess the first thing is when you said that you testified that Alex lived in Shirts. Is that right?
Yes.
Okay, but did you get that off of a driver's license or something like that?
Off of his driver's license and also confirming with him.
Okay, but did you realize that at the time his parents lived in Garden Ridge?
I did not.
Okay, but if they did, then that would be a little bit more understandable if he were going to that home.
To my knowledge, Garden Ridge is also located up 35 North.
Well, you can go 46 to 309, 3009.
Okay.
Right? I mean, you could from there. That's all I'm saying. Because I guess sometimes, as you know, people have an address, I guess, that's established, and sometimes they live with relatives or somebody else, and that's kind of their day-to-day living.
Like I said, for the purposes of my investigation, I confirmed with him that the information on his driver's license were true and accurate, and that's where he resided.
Right. And so I guess what I mean is, and I'm kind of talking about just a little bit, my question is a little bit different. It's, yes, we can reside at an address, but for one reason or another, we can also stay at a different address, like with other family members for, like I said, one reason or another.
Okay.
Would that be, you understand that?
If you're asking me if he was staying with his relatives, I have no idea, sir.
Right, and I guess that's my point. I mean, I just want to make sure that that everybody's clear that when you testify that he was living there, that doesn't necessarily mean that he was living there every day.
Okay.
Right, okay, so as far as these different, you went through with the jury, these different locations. One of the things that I think you're clear about is you're not saying that Alex was at any of these locations with that testimony based upon those documents, right?
Based strictly on the evidence from the track logs, I was stating where the vehicle was located.
Right, and you can't, based on that testimony or based on that evidence from the track logs, you cannot state where he was.
Based solely on that evidence, no, I'm not able to say where he was.
Okay, And so as far as, in some of these places, were there any like apartment complexes or residential kind of areas and streets that were around these places that you talked about?
Around, but not in the immediate area.
Okay, but there were around in different places that you talked about.
Yes,
All right. And I think what you read there was that he had said he was with a friend and then he left that friend and he was driving, I guess what he said in that transcript you were reading, he was driving home.
yes.
Judge, I'll pass witness.
Any further question?
Nothing from the state.
Is this witness excused or subject for recall?
We're fine, excusing witness.
Excuse from the state judge.
All right, the rule has been invoked. You're still not allowed to discuss your testimony with anyone until this case is concluded.
Yes, ma'am.
All right, you may step down. State, call your next witness.
Yes, Your Honor, the state calls Barbara West.